Today we're going to talk about direct examinations and what makes a good direct examination at trial. There are three things that we're going to talk about today in terms of how best to present your case in direct examination. Those three things, or those three topics, are prepare, speak, and listen. So we're going to go through each of those, prepare, speak, and listen, to best determine how to get ready to present your case at trial. Before we talk about those three things, though, there are some other areas that I think are important to remember in preparing your direct examination. Many of you have probably watched a lot of TV shows or movies, and in those TV shows or movies, you've probably seen cross-examination. Cross-examination is what's exciting. It's the go in and get you moment. It's the thing that TV shows and movies are made of. Direct examination is not cross-examination. Cross-examination is TV shows, it's high drama. Direct exam, however, is where you win your case. And that's why it's important to make sure that you prepare your witnesses and you prepare for your witnesses, that you speak clearly and think about how you speak in direct examination, and that you listen to the information your witness is giving you. Now, the most important thing about direct examination is to tell a story. That's what lawyers do. Lawyers tell stories, but the story isn't about the lawyer in either direct or cross-examination. The story is about the witness. The story is about your client, and your witnesses are going to be telling in direct examination the story of your clients. So, how do you go about telling the story? The first thing you do is you prepare. And the way you prepare is to make sure you are ultra familiar with all of the information, all of the facts of the case, not just the facts that your witness is going to present, but what are the facts that the other witness is going to present? What are the high points of your case? What are the good facts? What are the not so good facts? And you're going to prepare for all those facts by looking through the testimony you're given of the witnesses, any statements they may have written or given orally, what the exhibits are, what information do those exhibits show that you want to get across through your witnesses. You're also going to prepare by thinking about the objections you're going to make. What are the objections that you should anticipate, that others may make, that your opponent may make, in terms of interrupting your direct examination so that you're ready to continue on smoothly without any awkward transitions in responding to the objection and jumping right back in to your direct examination. In other words, you don't want anyone to interrupt your story. You want to be able to move seamlessly back in to tell the story. It's often said that lawyers should know the facts of the case like they know the back of their hand. They should be able to pull an exhibit out of a pile and be able to get ready to use it with a witness, even if you don't anticipate having to use that particular exhibit with a witness. So in thinking about what you're going to do is you outline the questions you're going to ask your witness in direct examination. You need to think about what's the purpose of this particular witness. Why are you calling this witness? Why is it important that this particular witness tell this particular portion of the story to the jury that's hearing the case? Probably the most important thing, and one of the hardest things to do in preparing a direct examination, is to narrow the scope of the direct examination. You want to make sure that with each witness, you're only trying to get across 2 or 3 key points, at most 4. The jury is going to be lost if you try and include much more information than that, and you don't want your witnesses on the stand for an inordinate amount of time. That's going to bore the jury as well as potentially the judge. So think about, what do you need to prove? What are those 3 or 4 key points? What's relevant? Don't worry about getting each fact in with each and every witness. That's how also you're going to determine in your preparation what witnesses you're going to call. Sometimes you have a witness who just makes a fabulous appearance, but that witness doesn't add anything to the story. That witness just muddles the story. You're not going to call that particular witness. Now, there are 3 types of witnesses that you might have in a direct examination. At the most basic level, you have your fact witnesses. Those are individuals who have basic information about the facts of your case. Perhaps it's someone who witnessed a crime and is going to talk about what they saw at the time of the crime. Perhaps it's someone who was the victim of the crime, or the person who was the victim of sexual harassment, or who lost a leg in a product liability case. Fact witnesses, you're going to ask quick, direct questions, and fact witnesses cannot give opinion testimony. So remember that if you have a fact witness on the stand, you don't want to ask those witnesses about their opinions. The court will exclude that testimony if it's objected to by opposing counsel. Then you have expert witnesses. An expert witness is someone who is allowed to give opinion testimony. When you are putting an expert witness on the stand in direct examination, you're going to frame your direct examination a little bit more differently, and we'll talk about that in a minute. The third kind of witness you might have is probably more likely in a civil case as opposed to a criminal case, and that's a witness who may have basic information about the facts because they're not going to be able to testify if they don't. But that fact witness may be on the stand not so much because they know a key fact, but because they're going to personalize a corporation or a business, someone who can't take the stand as ABC Corporation. And with those witnesses, you're going to want to make sure, especially, that the jury gets to know the witness as a person. So how do you prepare your witnesses to take the stand? With a fact witness, one of the most important things is to make sure the individual is comfortable testifying, to make sure that that particular witness isn't shaking when they're holding a piece of paper, doesn't stutter a lot, and that's preparation. It's preparation for you in terms of knowing what part of the story you want the witness to tell, and it's preparation on the part of the witness. I often have my witnesses sit down before video cameras and rehearse what I'm going to tell them, not so that their story sounds rote or memorized, because jurors can see through that, but to make sure they're familiar with the questions I'm going to ask them and the questions that they might get asked later in cross-examination. It's always a good idea with a fact witness to start with some easy questions to make them feel more warmed up, if you will, in terms of talking to the jury. Tell your witness to look at you, not to look at you, but to look at the jurors if they can. And a lot of that part of the preparation is thinking ahead of time and checking with the court about where you can stand, what tone of voice you're going to use. Some courts will make sure that the attorney asking the question does not leave the podium at all. Other courts will allow the attorney to move away from the podium. One of the tactics that many trial lawyers use, if they're allowed to, is to stand at the end of the witness box during a direct examination. What that does is force the witness to look at the jury in answering your questions, because it's normal in conversation for the person who's asking questions to look at the individual being asked the questions, and the person answering the questions, in this case the witness, to look at the person who asked the question. So if you're in a courtroom where you're required to use a podium, and the podium is located across the room from where the jury is, your witness is not going to naturally look at the jury. If you're allowed to stand at the end of the jury box, however, the witness will be more forced to look at you and by the same token to look at the jury in answering any questions. So think about where you're going to stand, what limits there are going to be, and then think about the pace of your questions. Think about the tone of voice. Again, in the movies and cross-examination, you hear people get excited and perhaps sound somewhat surprised or puzzled when they get a question or an answer to a question they're not anticipating. Direct examination is much more measured. There can be a certain flow to direct examination. You don't, however, want it to start sounding rote. You don't want it to sound totally rhythmic so that your jurors lose sight of what it is your witnesses are testifying to. You want to make sure that those jurors understand those 2 to 3 key points that you're making. Pauses can be important there. Sometimes I'll sit and ask a series of questions and then pause, maybe say something like, "Now let's go back a minute to the testimony you gave a few minutes ago." Those kinds of comments, those signals, will refocus the jury and perhaps refocus your witness. So think about those kinds of issues. Think about good facts, think about not so good facts. And that starts, and I've already started to get into the second area